In this case, which is titled Nathu Singh versus State of Uttar Pradesh, the Honorable Supreme Court reversed the concurrent findings of two courts, that is, Session Court and High Court, in which the accused appellant over here was convicted for murder and sentenced to life imprisonment. Now, see the contention which was raised by the appellant in the appeal. Firstly, that only one eyewitness stick to the stand, other eyewitness turned hostile. Secondly, the independent witness, that is Raju Panwala, in whose front shop the occurrence has taken place, was not examined by the prosecution, although he was examined by the investigation officer at the time of investigation. Now, one more important fact has happened in this case, that appeal by one of the co-accused was already dismissed by the Supreme Court, and as it was held by the Supreme Court that in this appeal the leave was granted prior to date in which the special leave petition of other co-accused was dismissed. Secondly, it is also settled that mere dismissal of a special leave petition does not amount to affirmation of the view taken by the High Court or the trial court. Now let us see what weighed with the Supreme Court in reversing the conviction of the appellant. Firstly, it was held that there was two witnesses, PW1, PW5, both had not supported the case of prosecution. Secondly, Raju Chaurasia, the owner of pawn shop in front of which the incident took place, was never examined as prosecution witness, although he was examined by the IO during investigation. Then the only witness which remained was PW3, Jitendra Singh, on which the conviction was done by the lower court. Now the Supreme Court scrutinized the evidence of PW3. The evidence of PW3 was not found to be trustworthy. On following grounds, the Supreme Court held that his statement, PW3 statement, was recorded after 2 months from the date of incident. Although he admitted during his evidence that he was at his house during the said period of 2 months. Secondly, the distance between the village and police station is only 6 kilometers and there was a Pakka road. So, therefore, the Supreme Court held his conduct during the said period is required to be taken into consideration, as the police station was at a distance of 2 kilometers from the place of occurrence, but PW23 choose not to go to the police station to report about the incidents during the entirety of the period. Second lacuna was PW3 in chief stated all of them were encircled by the accused persons. But in cross-examination, he stated only deceased Vineet was encircled by the accused and they were at a distance of 5-6 paces. Then when IO was examined by the prosecution, then there is no explanation why the witness statement of witnesses was recorded belatedly. The only explanation given by him that he recorded the statement of these witnesses after the investigation was handed over to him. That was not a plea which is sustainable in the eyes of law. The Supreme Court held there is inordinate delay in recording the statement of the witnesses, coupled with no explanation to that effect from the IO. Further, the conduct of PW3 would bring him in the category of witnesses who are not wholly reliable. Therefore, the Supreme Court set aside the conviction on the sole testimony of PW3 because there is no corroboration to his evidence. So, therefore, the conviction solely on the basis of PW3 would not be justified. The Supreme Court held the appellant therein is entitled to benefit of doubt. The appeal succeeded and the impugned order was set aside. And the appellant was directed to be set at liberty if his detention is not required in any other case. This judgment was passed by the bench comprising of Justice B.R. Gavai and Justice Vikram Nath on 19th of January 2023. Thank you.